The right to keep and bear arms is guaranteed to all persons in America by the Second Amendment to the Constitution. The Supreme Court recently held that right is fundamental, a Supreme Court code word for a natural right. A natural right comes from our humanity, which is a gift from God. The gift in this case is the legal right to defend yourself when the police are not there or when the police can't get there. It is also the right to defend yourself against the government if it is taken over by tyrants. When the framers wrote the Constitution, they had just defeated the mightiest army on earth because the colonists had and used their own arms. The framers knew and understood that keeping arms was the last line of defense against tyranny. They also knew that when the states formed the federal government, the states intentionally gave up just 17 specific, unique, delegated powers to form the federal government. And in doing so, they didn't give up any of our fundamental or natural rights. Yet some states, notably New York and Illinois, have interfered with the right to keep and bear arms, arguing that the Constitution only protects the right from federal interference. Well, how can this be? If the right to keep and bear arms is natural, how could any American government infringe upon it? My next guest has recently examined the relationship of the states to human freedom, and particularly with regard to the Second Amendment. Joining me now is Damon Root, Associate Editor of Reason Magazine and Reason.com. Damon, it's always a pleasure.
Judge, thank you for having me.
Just to set this picture, for 200 years, we never really had a definitive opinion from the Supreme Court as to whether the right to keep and bear arms is fundamental. And in Supreme Court speak, fundamental means a natural right that comes from our humanity. The Heller decision comes down and refers to it a half dozen places as fundamental. Then comes the state of New York and the city of Chicago, authorized by the state of Illinois, and they try and say, no, 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 we can ban the right to keep and bear arms because that Heller decision and that Second Amendment only keep the Congress off the people's backs, not the states. Well, what the heck kind of sense would that make?
Well, it makes no sense at all, Judge. What Chicago particularly is arguing in a case that the Supreme Court's going to hear in early March is that the Second Amendment should not apply to their gun control regime at all, that its Second Amendment applies only to the federal government, not to the states. Now, this is, if you think about what they're saying, is that the Bill of Rights spells out a number of individual rights that we possess, natural rights. First Amendment, Second Amendment, but they're saying, well, the First Amendment...
privacy, religion, travel, etc.
Right, to be free from unreasonable searches and seizures, etc. Fourth Amendment. They're saying that the First Amendment, the Fourth Amendment, some of these other ones, they're more important than the Second Amendment, that the Second Amendment doesn't apply to us. Now, if Chicago argued that they could establish a religion or censor the press or do away with the Fourth Amendment, the Supreme Court would step in and say, you cannot do that. And the treatment for the Second Amendment should be no different.
But somehow, because this is the least favorite amendment of the progressives who have created the big government that we have today, they will not do that for the Second Amendment. I mean, you and I were talking off air, and this is the essence of your piece. The states frequently were laboratories of democracy, meaning they allowed even more freedom based on their own laws and their own state constitutions than the federal Constitution permitted. But this is sort of the inverse of that, isn't it? This is New York saying, okay, we can do to you what the feds can't do because of what? The wording of the amendment?
They're making this sort of federalist argument, but as you say, it turns federalism on its head, and it dates back specifically to the progressives. Louis Brandeis, the Supreme Court justice, progressive justice, who made this argument that the states should be free to try out, I called them novel social and economic experiments, to be laboratories. But the laboratory he was defending at the time was an Oklahoma regulation that created monopolies in the ice business. Now, this is the opposite of freedom. This is the state saying some businesses are going to be protected. We're going to create a little cartel, a little monopoly, and we're going to keep out competition. So this is this noble laboratory that the progressives were defending. They're not willing to defend an actual enumerated right in the Bill of Rights, the Second Amendment, but they're happy to let the states regulate economic liberty.